Miss Sanford, you're not going to win.
My daughter.
Miss Sanford, there's nothing to win here.
It's
Stop.
not winning.
Stop.
I want to protect my daughter.
Stop.
And you said it was
Stop.
performative. I am protecting
Stop.
my daughter.
There's
and you said
nothing
it was
to win here.
Welcome to Rebel Chaser. My name is Gail, and I've got a video for you from Judge Tammy Long Hayward, and she has her hands full. I'll let you guys watch.
All right, so this is State of Georgia versus Benjamin S. Latta. Mr. Latta is represented by Mr. Moody, Bradley Moody, who's with him. This is case 2024 CR 00187. This is a motion to modify bond conditions. They are present, and the state is represented by Miss, is this Miss Ponder or Miss Hayward?
Yeah, Sharon, I'm handling this case.
All right, thank you. All right, so is the state ready to present?
Yeah, no, the state is ready. I just want to get some clarification. It's my understanding, and counsel, you can correct me if I'm wrong. It's my understanding that this is on for a motion to modify bond so that Mr. Latta can have communications with his child. Is that correct?
That's correct, ma'am.
Okay.
All right, how old is the child, Mr. Moody?
2, Your Honor.
All right, and okay, so that's gonna make it a little difficult. What is y'all tell me, what's the plan? Because if the mother of the child is the person who's the victim, alleged victim in this case.
That is correct, Your Honor. It is our understanding that Miss Sanford, she is the mother of their 2-year-old child, and it's my understanding that Mr. Latta is requesting contact with his 2-year-old daughter via Zoom. It's my understanding that Mr. Latta resides here and the mother does not reside in the state of Georgia.
That's correct, Your Honor. The mother resides in New York. Currently, Mr. Latta and the mother of the child are going through the process of legitimation, or at least Mr. Latta is going through the process of legitimation in New York. And in terms of custody and visitation, we've an impasse in that the court in New York will not hear the matter of custody and visitation based off of the no contact order from here in Georgia in Clayton County. So we're trying to make some arrangement to allow where Mr. Latta would be able to ultimately have some sort of visitation with his daughter.
Okay. Yeah, but this is complicated because the issue was harassing phone calls. The mother would have to facilitate the child getting onto a Zoom and manage that. And so what y'all are asking me for is to allow no violent or harassing contact limited to Zoom calls with the child. But that means that the mother has to manage it, and she's really not under my jurisdiction.
And Your Honor, it's my understanding that Ms. Sanford does not want to have communication with Mr. Latta. Is the reason, it's my understanding that counsel filed a motion to modify bond so that he can have contact with his daughter. As it's the state's position based on information that I did receive from Ms. Sanford, she's not comfortable with speaking to Mr. Latta, and she does have the child. So at that point, the state will defer to the court.
And the legitimation action in the, I guess, whatever the family court is, in what part of New York is this?
This is in Queens, New York, Your Honor, and it's not a legitimation.
That would be the Supreme Court, right?
Yes.
Okay, so the Supreme Court in New York is not going to have, they're not going to even entertain the request for visitation legitimation unless I remove the no contact provision. Is that what I'm understanding?
That is my understanding.
That's not correct, Your Honor. That's not correct.
Miss Sanford, give us
Ms.
one
Sanford,
moment,
hold
please.
on, ma'am. I'll hear from Miss Sanford, but Miss Sanford, hold on give me a minute.
This is pretty
Because I'm
common.
trying to understand, because some of this, I mean, I can say a lot of things. I order a lot of things, but Miss Sanford is literally outside my jurisdiction. She doesn't live here. The child is in New York. The only person I have control over is Mr. Lata. And
And
with
Your
that
Honor,
being said, I can order that Mr. Lata can have no violent or harassing contact and limit it to Zoom or text. But as far as whether that happens, that has nothing to do with me.
well, yes, Your Honor, and that's exactly right. I completely agree with that. And the screen just went out. Can you still hear me, Your Honor?
I hear you.
Okay, sorry, the screen went out. So I completely agree with that, and that's all we're asking for is the relief to allow the court in New York to make that custody arrangement or make that visitation arrangement. So I mean, as of right now, we're just at, I mean, we're at an impasse as to any progress in either of these matters. The case here in Clayton County or the family law matter in New York.
I get that, but the issue that I have is the action you're wanting me to allow is for him to make essentially phone communication with Miss Sanford for the purposes of seeing the child.
Yes, sure.
The alleged offense is based on harassing phone communications.
Yes, Your Honor, I understand that. I mean, this is an event from March 17th of 2023. At some point, at some point, these two people are just going to have to accept that they do have a child together. I mean, he's not never see his child.
I get that. Here's the issue that I have.
Yes, Judge.
Is a lot of people have babies and children together without first thinking whether this is somebody that they can stand over the long term. And this is essentially what I keep getting, like, it's not really my bailiwick. I'm state court. I don't have to do family law. Thank God. Because when I was a staff attorney in the family law division in Fulton County, I knew then that that was not what I wanted to deal with, because the most volatile practice is family law. That's where you give an inch, they'll take a month. If you say you can have a little bit of contact, then all of a sudden my words get weaponized. And the judge said, and that's really not what this is, because I can't order Miss Sanford to do anything. The only relief I can give is I'll say no violent or harassing contact. But the problem that I have is the contact that you wish to enable is what is the basis of the charge. And I just don't, I've never had a court with a jurisdiction over what I have say that they needed me to do something in order for them to do something. Here, if I say no harassing or no contact, a superior court can say, because they're a court of general jurisdiction, hey, I understand this order, but I'm going to order these specifics with respect to the no contact. I recognize it, but I can order this because these people are before me. The problem that I have here is, even if I say this, I can't control then what happens. And if this leads to another offense of harassing phone calls, then I've enabled it. I just want people to start thinking more about okay, it feels good right now, but do I really want to have a baby with this person? Because these issues are coming up a lot.
Is it possible?
Let me hear from Miss Sanford for a minute. Miss Sanford, raise your right hand for me.
Yes,
Hold on, Miss Ponder. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, I do, Your Honor.
All right. So tell me about your concerns, Ms. Sanford. Don't really go into the what happened, the underlying offense, because I don't. That's not what's on the table. But tell me about me giving contact.
So I would like to first express I vehemently oppose. I'm not consenting to any access between Benjamin Lotta, the defendant, and Emmy. Emmy is the 2-year-old, our daughter. As it stands right now, Your Honor, I have many pressing concerns. And what I'm surprised that has not been brought up already is that Mr. Lotta has an outstanding, and I'm going to be careful with my words because of how it's entered, but he has an outstanding warrant here in New York when he has been evading the police for the last close to 3 years by not answering that warrant. He has refused to come to in-person proceedings. His family court attorney makes excuses for him by just saying he can't come because he would get arrested. He has not tried to turn himself in. They have said that they cannot find it, but it has been stated on record several times. My previous attorney has been able to confirm he is a wanted person in New York. The terminology of it, with it being a warrant, it's not the exact terminology, but that it is an equivalent because the police department issued it and not the state. So that's why when you search it, it does not appear, but he is in fact wanted here in New York City for an offense here. Now,
What they call it up there, a detainer?
no, it starts with an I.
Okay.
But he is.
So you're objecting to any contact?
Yes, but I have other concerns as well.
Well, let me satisfy what I need to know. The child is fully in your custody and control.
I have sole legal and physical custody of Emmy Lynn at this time. Yes.
Okay, there would be nobody else who could facilitate the contact over Zoom, but you.
No, because one, Mr.
I'll
Lotta
have to
has
tell
made.
you why. If you have full custody and control and there's nobody else, that's fine. The less that the child's information is put out there, the better. I don't like.
I also want to just bring something else out there that in family court, because I'm pretty sure this is something that Attorney Moody would be prepared to say today based off of other testimonies made. The defendant has made requests for social workers to do the I guess, the Zoom exchange. Now, in the past, I have already consented to Zooms. I have signed stipulations granting the defendant access, but I withdrew it because one, he did not have Georgia's permission, and two, he was actually actively abusing government agencies during that process. And just to talk about my safety concerns when it comes to the defendant and Emmy Lynn, the defendant has sworn under oath in a criminal trial in Fulton County that he instructed someone to call CPS with false allegations stating that I was going to kill my daughter. And this is in
okay. This is all I need to know. Ms. Sanford, you're not testifying for this, Ms. Sanford. I don't want to know anymore because what I don't.
The reason why I'm bringing that up is because I don't want to
Sanford
around my daughter.
This is what I'm saying is y'all start testifying whenever it's a family law issue. Y'all start testifying for whatever the next hearing is. I don't need to know all that. What I need to know is whether it makes sense for me to grant the modification. I think I've heard enough where I'm not comfortable granting the modification. I think, what, Ms. Pond?
Is it possible if I can have a breakout room with the court as well as with defense counsel?
Please.
Okay, 1 second.
Hey, Judge James Fulton just checked in.
All right, Mr. Fulton. Yeah. I didn't see Mr. Fulton's name on here, so he must be for 1 or 2 o'clock. So
relax, Mama. Please go have a seat, baby.
Let's see. Okay, so I'm gonna put the courtroom and Ms. Ponder in breakout room number 1, and then I'll join. And Miss Sanford, I'm not real comfortable with your daughter's picture being on. She's a minor, and this gets broadcast. You know, you got her picture up behind you. I'm not comfortable.
I'm so sorry. I thought her face was blocked because on my end, I can only see her elbows.
I can see both of her, both pictures.
Oh, wow. Sorry.
Yeah.
On my end, I put it at an angle where I can only see.
I got you. But I'm, just not comfortable with that.
No, thank you. I'm not either. Thank you. Thank you. Is that all you see now? Because on my end, I was only ever to see her arms down.
Yeah, it's better.
Thank you.
Thank you. All right. So here's the thing. I have issues when we have cases like this. And the issue is that both parents seem to lose sight of the fact that there is a vulnerable child in the situation. And it becomes very performative. everybody's fighting and yelling and going at each other, and nobody, Miss Sanford, you can look at me all you want to, but I've been in this game for so long. The pilot program for Fulton County Family Court, I was one of the staff attorneys who helped to get some of the forms done, who sat through mediations, who trained extensively in family law, and then decided I never wanted to do it, because what people do is they weaponize the child, and they don't think, I work alone. If I need you, I'll let you know. They don't ever think about what it means to a child to have parents who fight continuously. Now, this is the issue. At some point, y'all thought it was a good idea to sit down and exchange bodily fluids and have a child. At some point, this person who's on the other side of the V made sense to you. Now, unless it was an arm's length transaction where this was done through a clinic or something, or this was a surrogacy issue, but I'm not getting that. I'm getting that you all chose to have a child. As a child of divorce, and it wasn't even a contentious divorce, I will tell you that both of you, until you learn how to co-parent, are going to ruin your child. I'm just going to say it. You're going to ruin this child, because she is going to understand that she has two parents, and if she's denied the time to be, or the opportunity to be with one or the other parent, she's going to resent that. I grew up without my father in my life, and I'm going to tell you, I didn't resent my mother. I knew the circumstances, but I did resent that he wasn't present, and I grew up without him. So what I tell you is, at some point, you got to put your claws in. You got to have a little bit of humility, and you got to listen and structure this in a way where y'all may never like each other. You may never deal with each other directly, but y'all have got to figure out a way where this child doesn't feel like half of them is not a good thing. The child is always going to know that they have a father and a mother, and if they don't have access to one or the other, it's going to hurt. Now, Ms. Sanford, you came on here and I'm listening to you, but as a mother, I would have never shown my daughter's picture. I would have never said your daughter's name.
Your Honor. That
you
was
said your
not
daughter's name multiple times. You've shown the picture multiple times. That to me is performative.
Your Honor, may I just intervene, because you made a few statements that are very inaccurate, okay?
Y'all didn't choose to have a baby together.
First and foremost, let me just make it clear on record.
Y'all didn't choose to have a baby together.
I chose to have my daughter. He told me to have an abortion. And I'm now, let me just start, because we're going into things that's not relevant, and I don't speak about these things until in the presence of my daughter. Your Honor,
I'm not doing
Your Honor, I offered Mr. I heard.
Okay, so to the extent that I am holding up the family law court from making a decision in this case, I will grant a very limited,
Your Honor, may
modification. Ms. Sanford,
mention what I was going to say. You made some statements, and I would like to.
I will grant a very limited modification of my order. It is to be no violent or harassing contact, no direct contact. Any contact will be subject to text messages. If there is Zoom contact, the Zoom has to be recorded so that there's a record for the court. No physical contact, no in-person contact.
I'm going to appeal it.
You can do whatever you want to, Ms. Sanford. No physical contact.
5 negotiations that he declined.
So that the family law court in New York can make a decision, because I don't have jurisdiction over family law. My jurisdiction is literally limited to this particular misdemeanor offense in Clayton County, Georgia. With that being said, Mr. Lata, let me explain to you, outside the very narrow confines of what I've ordered, let me explain what happens if you violate. The possibility exists that you could have your bond revoked and you could remain in jail here in Georgia in Clayton County until your case is tried. It also, there also is the possibility that you could be charged with additional misdemeanors or felonies, particularly the felony of aggravated stalking, which is punishable by up to 10 years in prison, a $10,000 fine, or both. I'm not just giving you these cautions. Everybody who has a bond and a case where there is a victim on the other side, and it's not a traffic offense, I go over these bond conditions and the issues of bond with them. So with that being said, I will limit contact to text, to Zooms if they're recorded, and no in-person, no telephone, nothing that can't be seen by or reviewed by a court. No, that is the limitation that I have, so that the family law court in New York can address these issues and can make a determination that might be permanent between these parties, because I don't have jurisdiction on that.
Your Honor, it has been suggested in the family law court in New York, the possibility of having some physical contact as supervised.
No, that has never been discussed. That has never been discussed. And I'm not getting the opportunity to speak.
I've done all that I can do. I would presume that a superior or Supreme Court in New York, which has jurisdiction over family law, can make whatever decision they want to make. And at some point soon, I hope, this case will be tried or resolved through a plea, and my jurisdiction over these individuals will, or this individual will end. And so my decision is limited by the fact that I'm not holding this case forever. If you talk to the state and y'all can pre-try this case and y'all get it resolved, that's fine. If we put it on a trial calendar and it goes to trial, that's fine. But I'm not going to have the level of oversight over these parties that the family law court will. So they can do what they want to do. I won't be offended, promise. I promise you. So with that being said, draft the order. I'll sign it and get both copies to both parties.
Your Honor, may I please clarify one statement?
What statement, Ms. Chair?
Thank you, Your Honor. I want to make one thing clear, because you did give us a well-needed lecture, but I want to make one thing clear. The defendant was offered not one, not two, but 5 custody and visitation negotiations from me when I was pro se and represented. He declined all of them. And we're talking about over the course of 3 years, the child is only 2. I have also signed 2 stipulations for him to have access to the child. Let me speak, please. I have signed 2 stipulations for him to actually have access to the child. He never asked permission from the state of Georgia to get it. So it's not performative. There are things that has happened between then and now where he has put my child and myself at safety, doing background checks to find our address, making police reports. He's made threats to my fiance, all things that has done between then and now. It's not performative. And if anyone, I don't need any.
I didn't say that was performative.
Well, nothing is performative. If my screen is this big, my screen is this big, and from here I can only see her elbow down. I protect my daughter at protecting my daughter.
Okay, so I made my decision, and that's what
I will
say.
Go to any length at anyone's expense.
I made my decision.
Protect my daughter.
I made my decision.
And he has a warrant. You made this decision knowing that he has a warrant here in New York against me and my child. So I'm going to appeal it because he has already violated. He's already violated the New York order of protection.
If they wanted to exercise the warrant, they would.
Yeah, he has not. He's been evading the police, Your Honor, this entire time. He has a warrant here for a crime committed against me and my child.
Ms. Sanford, you're not going to win. Ms. Sanford, there's nothing to win here.
It's not winning. I want to protect my daughter. And you said it was performative. I am protecting my daughter.
There's nothing to win here.
It's not performative.
You will not protect her here.
Yes, I am.
This is what I've said. I've done what I've done. Get me the order.
And I'm going to appeal it. You did this knowing he has a warrant.
I'm not scared of the appellate court. Appeal it. All right, hearing over.
For the things that he has done already to me and my child.
Hearing over.
And I will.
All right.
Well, first I want to say she chose this man, and he may not be the best choice in men, but that's who she picked. That's who she stuck with. But everything she did was performative. From the location where she sat, she wanted her daughter's picture behind her. Granted, she said she could only see from her elbows down, but that means that she actually looked to see how much of her daughter she could see. She could have sat somewhere else. She could have sat on the other side of the table, but she wanted those pictures behind her because that just shows the judge how much she loves her daughter, right? That's performative. By trashing him, this is not a family law case. This is a misdemeanor in Georgia, not a family law case in Georgia. The family law case is in New York. But this mom wanted to litigate this case in front of Judge Hayward because she wanted to be able to trash him to Judge Hayward, so that then she could take that back to the courts in New York and say, well, see, this judge wouldn't allow him to have contact. Well, that's why I think the Judge Hayward said, I will allow limited contact. I have a feeling that's why, because she did not want to be called on as a guide in the family law case in New York, which this mom would have brought that to their attention. But trashing him to this judge, trying to go toe-to-toe with this judge, saying that I will protect my daughter at all costs. Well, most moms would do that. I shouldn't say all, because not all would, but most moms would do that, protect their children. But everything, all of her actions in this court case to Judge Hayward were performative. And that's exactly what she was talking about. It's performative. Everything. So that's the way I see it. So thank you guys so much for watching, and I'll see you next time.